So hulle poog om nuwe vereistes by te voer vir die omvang en frekwensie van sodanige progress in the applications. Like I said, dat is de taal denkbaar in de rekening van de arbeid in de woord. So dat ja, als ik de taal is, ik krijg het zeker zo weer, dan wordt het zo gepast. So dat mensen kan zeggen dat het onbeveiligd wordt.
We have a person in charge. We are expanding the definition to include now the person who has legal authority to administer or control the land in question. And this will allow the municipalities to intervene by initiating eviction process even when it is not the owner of the land that is invaded. So we know that what would then happen in practice currently is that the municipal officials may be able to see people unlawfully occupying and try to block that by going to court to request the interdict. But when they arrive there, they are told that they are not the owner of that land, and it becomes difficult to stop that unlawfully. And the result thereof is that by the time the owner is found, after 2 days or so, that land will be occupied by hundreds of people. And it becomes the first point of entry is that person must provide alternative accommodation. And that person will then, the owner will say, I do not have the money, resources to do that. And it will be the responsibility of the municipality to provide that alternative accommodation. But in between is that the municipality will then be expected to provide water when normally would be just a high mast line and abortion facilities as a human rights issue. You will not leave people and say because they occupy that unlawfully, they must not get water. So, and that then shifts the budget of the municipalities on items that ordinarily, even yourselves as the community will have requested on IDPs to say, we want these things to happen. So the money will then shift towards taking care of that thing that was not expected.
Die hof voorzien van alternatieve accommodatie. Die hof kan geven en stellen aan alternatieve accommodatie onvoorzien wordt voor die mensen met gezet. En dat alle mensenrechten bepaald worden, water krijgen, alle mensen is dat je goed kan passen. De water die we zien met de toiletten is allerlei iets dat je kan passen ook in verschillende waarden kan passen.
Currently, the Act is putting an offense to someone who allocates pieces of land or allocates people to buildings and receives money when it doesn't. We are now saying it must be expanded to people who incite others to occupy that is not theirs. So the offenses are now expanded to those who incite others to occupy their buildings.
So this is kind of being to the procedure to be done. That's the misstaat. Als iemand mensen aanhoudt om dat bezit of geld voor vrouwen in erg voor wat die aan de doen. So die weet zelfs als jij niet geld vraagt voor die erfenis, is het steeds een misstaat als je mensen aanhoudt om jou te zeggen.
Currently, the Act does not talk about the maximum fine, and we are introducing a maximum fine of 2 million, not 2 anyone be found guilty of committing these offences that I'm just talking about.
So the chances are we kan realize dat die gewoon gedaan. Dit is of twee jaar, of jy dan 'n criminal fire as jy uitgevind word. As jy gaan
Thank you. Currently, the money that is found, the person is found guilty. If he's found guilty, he can take the government will take the money and repay it to people who would have paid the person who was saying the states. But if they don't find that person, it must then be given back to national revenue. But we are now saying that it must be expanded to include assets that that person had acquired using the money when they were selling pieces of land, or also that we are saying that the money should go to municipal operating account, not the national revenue. This is because we realize that the municipalities are the ones who experience serious challenges having to pay this money to assist on alternative accommodation.
So dat is nog wel een probleem om in een reis te blijven functioneren. So de vraag dat we voor een nieuw en die omstandigheden wil je of dat zeggen of die orde ja. This is moeilijk om daar te lezen in het Afrikaans te doen. Je mag acties voorzien naar in mijn geval. Kijk eens naar de loop van de week.
Thank you, my brother.
Sorry, no?
Oh.
Go ahead. Just put my thoughts together.
Yeah, just. I can't hear.
You can continue and then I'll finish that.
What?
Yeah.
What?
I'll come back to you now.
The current act separates people who were unlawfully occupied land 6 months before and those who occupied it after 6 months. And they could separate the way of considering them. Whether they would get alternative accommodation or not, we are doing away with that part because general law for application does not necessarily allow that you can separate the same category of people. And the court is now consider that whether we are just removing this 6 months part and saying if people are lawfully occupied, they are. And then there should be same considerations that must be taken into account. Though the period will still be there to consider. I know that we have been raising my hand. Thanks,
I just want to ask a question.
They will give you the money.
Good morning, everyone. I just want to ask a question. Is this how Cape Town? We go to because we have mentioned some things there where we are still settling, and the court already gave a decision how many years ago? 7 years ago, and we still sitting in the same place. Thank you.
Thank you. No, I think we will still have questions. For now, let me present. Let me finish, then we can then go to the next session of questions and answers and questions. That you have. Thank you very much. On agent proceedings for evictions, the court will consider whether it is just equitable to grant the order. It is required to take into consideration the circumstances of the unlawful occupation But in the bill, we are now requiring the court to consider the pace, scale, and frequency of such litigation. The bill further seeks to introduce a mandatory joinder of the municipality jurisdiction and the relevant provincial Department of Human Settlement or any other organization having interest in the proceedings. And this will, we think that it will help in the issues of where the eviction would require alternative accommodation. Because sometimes when we go to court, the only people who are cited in the court papers, it will be the municipality. And later the municipality, when the order has been given that they must provide alternative accommodation, the municipality then says we do not have money, we can't provide that. And it takes longer because they have to go to court, request the money to get the alternative accommodation. And we think if they are already included from the beginning, it will be quicker to assist them in tapping on the alternative accommodation if it is needed in that situation. The bill seeks to introduce a mandatory joinder of the mandatory joinder of the municipality. As I finish? Oh, okay. The bill seeks to expand the powers of the courts to make orders relating to the retention or demolition or removal of improvements or structures on land, retention, taking, or harvesting any crop, and the payment of compensation for any improvement, structure, materials, and crop obtained by one party from another. We all know that unlawful occupation is not always the same. There will be people who would have seen vacant land and but there will also be people there will be people who originally they were renting a property or piece of land, and with their agreement, the owner they agree that they will make improvements with the rooms there and so on. And when you are being evicted, you are just being evicted, and it's not being taken currently for an account that you would have made the mistakes with the agreement of the owner, and we are saying that must be taken into account, and the court can then say you must be compensated for the money that you used to improve the structure, even when you are being evicted. You must then be paid. But the court will take that into consideration, put the addition that will be put on each of the parties involved. The bill empowers courts to make an order related to provision of alternative accommodation and requires courts to include in order the period of which alternative accommodation or land need to be provided for unlawful occupiers. The bill introduces a mandatory appointment of a mediator in an eviction proceedings where the municipality, the owner, or person in charge of the order was paid. And this means that where say the vacant land or building is owned by government, in short, whether it's municipality, province, or any department, instead of immediately starting the eviction, the NEC must appoint a mediator who will intervene and call all parties who have interest and sit down with them to try and resolve the dispute. So in that it is in the sense that the mediator will make sure that if there are people who need alternative accommodation, they are separated, and those who qualify for any other program of the department, which can be what we normally call the first home finance, where people can afford a certain portion of a bond, and the government then pays another half. There are those programs in the department, but there will be those who qualify for RDP house, and there will be those who qualify for rental stock, they can rent the property, they do not necessarily want to own, because they are coming here in Georgia for purpose of working, but they do have their own houses somewhere. They can then be able to separate those people and be sure that not every road requires necessarily alternative accommodation. But we also want to emphasize that we are putting more emphasis on vulnerable groups, for who qualifies for an alternative accommodation. And those vulnerable groups largely would be people who are children, elderly, women-headed households, and people with persons with disability. Those are our extremely vulnerable people, but also that there are those who are, they come on their own, provide alternative accommodation. The bill seeks to give discretion on the grant eviction order requiring the municipality or the state to provide alternative accommodation for rent. As and when they make a determination, they can make that order to say there is no need for that, because all these people are able to afford them to get an alternative accommodation. That's why the court can be. The bill seeks to bring, in conclusion, the bill seeks to bring balance between rights of unlawful occupiers, the landowners, and the municipality. And for unlawful occupiers, enhances protection and prevention of arbitrary eviction. So, a provision of alternative accommodations for vulnerable refugees, or those who cannot on their own provide alternative accommodation, and mandatory mediation when land belongs to the municipality. We are aware that the prevention of arbitrary eviction is in our constitution. It's a right in section 26, subsection 3, which says that no one can be evicted without a court order. So if you are evicted without court order, that is not a lawful eviction. If the person is evicting you is not able to show you a court order, that is not a lawful one. So we are still maintaining that it must be in terms of the law, evictions. For the municipalities and landowners that produce the provision of alternative accommodation and lawful occupiers who are not in a category of vulnerable groups, quicker eviction order when courts make certain considerations such as pace, frequency of land occupation, and reduce legal cost for mediation that succeed. For the property developer and investors, the greater legal certainty, less risk on project based from disputes, and reduces reduction of prolonged and expensive legal cases. We really believe that the mandatory part of having mediation between indeed help the situation instead of going to court. This will shorten the period. That's what we believe in, and the process will enable the public to make comments and input. This process that we are defining, we are seeking to request yourselves to make input on what we have here. You may add new things that we think we have not included in the bill, because this is not a new act, but we are dealing with the one that we are having. If there are new things that we want us to add, or things that we think we must remove, we can suggest that. And this process is about that. And when we are done, the process was open on the 16th of April until the 16th of June, where we will be taking these public comments. We are moving throughout the country and for people to make these comments. Others are doing them through the email at High Court Amendment Bill at dhs.gov.za. Others are writing to the Department of Human Settlement 240 Southside Justice Mohammed Street. They are writing the attention of officers to do that. So we will, after the 16th, we will sit down and the department take all the comments that are written, but also those that we are getting from this kind of information sessions, and collect them and refine them. The things that you see in front of you, and add those that we think as and when we move around, we get those additions. And we will then also be able to take out those that we think they are not, people are saying they must be taken out, and depending on the discussions that we have after that time. And thereafter, we will then, as a department, take it back to cabinet. And then the minister will then, after the approval of cabinet, we will then take it to Parliament. And then the Parliament will then carry again the process of public consultations. We'll come back to people and say, make your comments, and this is what, as a Parliament, the decision that will be made out of the bill that is in front of them, and bring it back again for your influence or not. I also want to indicate that there is our people should also know that there is rental housing tribunals, and it's not on what I'm talking about today. But I just want to share this information with yourselves, because sometimes there's a relationship between a landowner and landlord and the person who is renting in property. And you sometimes experience challenges there. And it happens two ways. Sometimes the owner wakes up and switch off the lights, and the water, we've got nowhere to go. Or he doesn't also take care of his property and complain until cows come to him, and you end up having challenges. Even the owner then saying that this person is not paying the rent, and that's why I went to business. So there is a rental housing tribunal, even here in Georgia. I think it does exist. And we will urge, if those kind of challenges, approach them, it's free of charge. You approach them, they should be able to adjudicate your matter speedily to resolve the issues that we have with the landlord, or the landlord is with the tenant. So we urge you to really use that facility to be able to be held on such challenges. We know that these challenges, this act of power came in because our people were being evicted without court orders during the previous years of apartheid. And when this act came in, it was intended to make sure that people are not evicted without really being humane, taking into account other factors that may lead to what they would have done. So I think it's important that we also have that background, but also not to allow a situation where other people are just abusing the system. And people are just continuously occupying even those who have been allocated the RDPRs, they set it and or rent it out and unlawfully occupying another place. So it shouldn't be in that fashion. We know that government might be facing some challenges in the provision of houses, but I think that's one to measure. Thank you very much. Interpreter, you may proceed.
Als het al praat, is het dat mensen aandacht so nieuwe wet sê dat selfs as jy geen geld vra, is dit steeds in misstand as jy mense aan het ontstaan en geld aan kontak mee. So voordat besluit die mense vrygesit, moet daar regtig na sê dat julle regsgelyk kry. So hierdie wet maak nie net soort van daai so die opmerking regelijk gekeken als een soort van omstandigheden voordat enige iemand uitgezet kan worden. So die wetgeving van die open die recht specifiek te beveel dat de alternatieve bewijzen voor onvergelijkbaar gevonden worden. So als je opgesluit die krachtige bezetters wordt dan alternatieve bewijzen krijgt en je ook precies zegt dat hoe lang dit gedaan wordt. Daar denk ik of niet gewoon naar de stuk kan gesteld worden in de municipaliteit. So die wetgeving is een makkelijker gemaakt om mensen te volgen waar gronden zijn om te leren. So zelfs al doen we dit verdiep waar de vermogen hebben om te kijken waar mensen gaan blijven in zijn leven. Dus de wetgeving dat blijft om daar een baie van bevinden zich in de recht van de grondeigenaar en die mensenrechten van de bezitter. So, en de certificatie en recht, en mensen niet net zomaar uitgezet worden op de straat of gooien worden, als ze een leerling zijn in gaan. En dit is een beetje een crisis en alle bezitters dit doen ze allemaal. Bij mensen dat nog mensen achter jaar blijven of niet ingezet worden als je recht wordt enzovoort. En alles dit is onzeker. So, wat ik nog zeg is, als mensen ingezet worden, kijk, het is dus onder een jaar dan is het hard dat we het gesteld worden. En die moeder is tussen de municipaliteit, zodat jij niet zelf moet hohe onkosten zijn, loonkosten zijn voor jij moet zelf niet gaan. So die optie die waarop is, so die wijziging gee dan voor je hoofd die rechten mag om die municipaliteit te beveel om hierdie grond of accommodatie gereed te krijgen voordat de uitzetting mag plaasvind. So die eienaar kan dus niet met die mensen verwijden voordat daar amper een nieuwe plek beskikbaar is. So dit moet obviously moet dit vir 'n sekere periode gedoen word, nee, so daar moet 'n tydlimiet moet daarop beskikbaar gestel word en gesê word vir hoe lank dit moet gedoen word. Mense kan nie net meer vir jare op 'n stuk grond neergesit word en daar word hulle gekyk en of daar ons spesifiek gesê hoe hulle verstaan. Okay, julle verstaan eigenlijk is wel kijk. So dit geeft allemaal dan ook rechtszekerheid. De municipaliteit weet dan ook precies hoe lang hierdie specifieke groep mensen dan nou op die stuk grond gezet wordt. En die bezitters weet dat die moordbewijzen ook niet permanent is. Dan kan je dit ook verstaan. Je ons ook kijken naar de municipaliteitsvermogen, dat hulle geld en grond beskikbaar het, maar soos eigenlijk sê dat in baie van die gevalle het die municipaliteit nie begroting om na mense te kyk en vir alles is dit noodwysig is. So dan word daar gekyk na dat die provinsie moet dan die municipaliteit bystaan om mense noodwysig te kan gee. Alles is nie 'n simpele huis, 'n baksteen huis nie, maar dat jy dan net beskryf kan opsit en hoekom in die dak kry, reg? Okay. Ek het gesê dat daar is dan die tyd vir kommentaar is tussen die 16 April en die 16 Julie, sodat mense kan kommentaar lewer op die wetsontwerp. Maar die wysiging probeer dat uit te maak in 'n situasie waar uitsitting jarelang in die hof besoer, en dan nêrens soort van waarin mense weet nie waarin dit moet gaan. Julle weet almal by huising is ons ontstaan onder tande sorg. En as jy nog by huising kry, dan is dit baie duur. So jy moet basies met 10 ander mense in 'n huis bly voordat jy 'n huis kan kry. So, doen jou deel, gaan lewer kommentaar. En ek sal kyk om ek sal die presentasie sal vir julle in Afrikaans kry, sodat julle die wat dit wil hê, kan dan na my toe kom, ek sal daar agterna, en dan kan julle die presentasie in Afrikaans kry by my, as jy dit wil hê.
Thank you very much for the presentation, and a good work done by our translator. Can we give them a round of applause, please? Thank you. Now it is your time. When is it continuing? Now it is our time for us to make inputs, questions, clarity-seeking, enhancements. There is no wrong or right answer. We do have a facilitator here, so that also gives you an opportunity to ask in Afrikaans. Then I will leave the translation. By the show of hands, let me identify you. But before I can start today, let me also elevate this important part. Your input is very important because you are not only doing it for yourselves, you are doing it also for your generations to come. The amendment bill as proposed, you enhance it in the way that also is forward-looking. Will it serve your generations well in the future? It's no longer about us. We are looking for the benefits and the future of our great children. I will start from my right. Let me see those hands again. You'll be number 1 set, behind you number 2, number 3, number 4. Now we come back to this point. Can we check the forehead? Number 1 set, please.
May I ask? Thank you very much for the opportunity. First of all, there was something very important mentioned, and that's about the RP houses. You say that people get RP houses and they go back to the informal settlements and stay there and rent all their houses. What are the rural government doing about it? Because they are doing absolutely nothing. They see it in front of them every day, and they do absolutely nothing. They know what I'm talking about because they are familiar with it, they know me. The second thing about people in informal settlements that are extorting people and asking them money. What is the local government doing about this? They know about these things and they do absolutely nothing. It's been brought to their attention in how many ways, and they are doing absolutely nothing. So what's the use of doing all this and the implementation doesn't get done? That's my answer. Thank you.
Very well. More seats, most calls. Die mensen wat een systeem maken is. Als daar een manier dat die inkomsten per van 3.500 voor jaren opgeschreven wordt naar 5.000 rand. Dat allemaal is het. Dus het hele story wat kan niet blijven aan die jaren dat je op de dag zit. Voor bij 3.500 rand. Zijn geld, zijn salaris, kijk op. Zo is het voor je. Tweede ding wat ik wil zeggen, daar wordt nooit gekeken. Ons middelklas mensen, dus die mensen wat in de staat werken, politiemannen, onderwijzers, mensen die werken in de municipaliteit, dan kan je eens krijgen. Daar moet ook gekeken worden voor ons middelklas mensen. Derde ding wat ik wil zeggen, en roosvolgen en al die anderen bij them. Ik wil graag die vraag, kan je niet die municipaliteit helpen in de TRT, wil daar zitten? Maar mensen van orde kunnen blijven. Maar ik zou denken van een grootje afmerk. En die staat met die municipaliteit ja, om van de structuur op te zetten. Die mensen niet in staat is om structuur op te zetten. Als dit gedaan kan worden. En behuizing is baie belangrijk is op hand van die mensen wil. Daar zit zo baie mensen op zich. Hier was 20.000 mensen op die wachtlijst. En hoe gaan we die wachtlijst aan spelen? En die jaren moet mensen gaan leiden op die ambtelijke wachtlijsten van die municipaliteit. Dat is mijn hartstikke belangrijk. Want ons mensen skreeuwen. Want hulle die buitenleiding. Nou met die storm, mensen zijn buiten. Kan die municipaliteit en die staat die municipaliteit helpen om van die mensen structuur op te zetten. Maar die mensen is niet in staat om een structuur op te zetten. Want hij lang gevraagd, jaren van om een structuur op te zetten. Hij is hier in het bestaande, hij is hier gekregen. Hij moet zich ook gehelpen om en alleen niet gevonden om er eens op te zetten. Dat is wat ik zeg, maar heel dank voor die voorlichting.
Goedemorgen allemaal. Ik heb een vraag aan de termen van de regio. Hoe beschermen de huurders aan de private plekken hier? Jy is bekommerd is huurder, maar met de existentieel van leerder daar naar boven. Ik zit hier in die wetdemocratie van alternatieve accommodatie. Wat gebeurt als je binnen de leerder daar met de alternatieve model bij de lasten naar boven? Maar hoe maak je zo geval?
Wanneer ik hierdie begaan heb, dat het regime en die positie dat de grondpunt van bovengraaf en het begint dat spannend voor. Ik wil specifiek die municipaliteit aanpakken voor gebrek aan consultatie van de regering. Maar ja, voor precies maar geaccepteerd wordt zonder de consultatie. Het beleid alsof die municipaliteit die een plaatsen verhoed is om die erfrechten van die plaatselijke inwoners te ontkennen, hier legalies praktiseren, die inwoners erfrechten zijn de eigenaars en die tegenwoordig vandaag. Maar collega's vooraan doordelen, artikel leerdienst en die grond nodig worden zonder consultatie met de eigenaar contact maken. Die vormen gebruiken voor terugdringen en was recensie die door de kennis om voor specifieke legalies van de municipaliteit. Mijn vraag is, kan die eigenaars van die vormen in de municipaliteit die voor de eigenaars kan wel opnemen? En dan vraag aan de want het is een schrijnende schande dat de mensenrechten ontkend en miskend worden. Die redelijke aspecten. En ik is geladen hier op mensen wat gevraagd. Wanneer eindigt hierdie worsteling, In die jaar 2000 tot 2003 is daar die munisipaliteit sociale wijze toegekend en allerlei tot meerdere regionale in daarvan. Diezelfde sociale wijze is toegekend aan Nederlands, maar om bestaan die is het niet toegekend worden. Mijn beroep is voordat ik bij mijn beroep kom, grond door bij ons om wettelijke wijze een voorbeeld van is dat de land wat toegekend is in die provinciale administratie voor volunteer vrij vrij wijze. Maar als je vandaag naar het land toe gaat, is het exclusiever ontwikkeling slechts gewerkt voor die mensen in de grondwezen. Die inwoners van Pacaltsdorp, Pacaltsdorp, die zeker naar de grond. Diezelfde gebeuren in de tweede en daar was nog een plan ontwikkeld van die rechterkant van die getuigen. Weer eens gronden van nieuwe van ons mensen in ons kandidaten voor de verkeerslagen gedaan. Bij ons antwoord van de vereistes kan die municipaliteit overgediend worden van 3 projecten die verdwijnen en inwoners.
Thank you. Thanks for in the video. Number 1, sir, and number 2. Let me take this side as well. Number 3 and 4. Thank you. You can have 5 minutes.
Please. Goeiemôre almal. Bawang kita masalah, bukan masalah yang mengenai mengenai. Lalu, sama yang orang semua memikirkan sekarang mereka biasa berbuat kita. Dan kesan semua lihat, ada si lihat, baton start lihat balas vandaag is. Ons wordt beloftes gemaakt, en ons taak moet. Ons gewone wordt gevat, zonder moet onze community om uit tafel te zitten. Pacaltsdorp is een breed genoemd gemeenschap, dat is onze erfenisdorp. Maar ons het geen sê hier die municipaliteit maak wat sy wil. En wat buiten betreft, ons mensen het geen voordeel in die huise nie. Buiten mensen krijg je huise. Nie buiten gemeenschap die Pacaltsdorp nie. Hoekom is die municipaliteit so tweespalt? Hoekom ons mensen moet eerste voordeel kry en die huise nie buiten mensen nie? Dat is ons dorp nie. Nie die wat regering nie. Hulle kom kry ons hier. Nou waar lê ons te staan? My dogter word onwettig deur die polisie daar gehuid in die gebied. Terwille van wat? Terwille van geslagsgebeeld. Ons is nie daar om mekaar op te jaag nie. Ons is daar mekaar af te breek. Ons kyk nie terug na die armes nie. Jy wat dit wil meer hê as wat jy het. Jy het die gemeenskap daar geplaas, maar jy is niks met die gemeenskap te doen nie. Nou wat beteken julle as leier van ons gemeenskap op die vloer? Waar ons is kleurling mense, se regte, ons het nie regte nie. Julle het alleen regte. Ons mag niks mag ons opstaan doen nie, want ons word gedreig in alle opsigte. So waar is ons mense regte? As julle praat van 'n nuwe Suid-Afrika. Waar is die nuwe Suid-Afrika? As julle alleen regeer. Ons mense het die regering nie. Ons het die grond nie. Julle het alles van ons afgevat. Wat moet ons nou nog doen? Ons het die regte nie. Julle het alleen die regte. Julle het alleen die wette. Waar is onze wette? Ons het nie sê op onze gronde nie. Ons het ook nie sê al oor onze kultuurlijke lewe nie. Al onze erfenis word van ons geneem. Die wet is baas oor alles van ons. Nou waar is ons as julle alleen wil regeer? Ek soek 'n antwoord van die government. Want die government is die een wat die beloftes maak en verkeerde mense aanstel om nie die regte van ons mense te erken in die land. Ons is die eerste nasie en die land behoort aan ons. Ons is die laaste reg hierso. Nie wat nie. Gee ons mense 'n geleentheid om hulle self te bewys. Dis wat ek vra van julle. Nie apartheid nie. Nie apartheid nie.
Again, good morning. I'm going to be very strict today. I'm going to be very strict today. As I said, straight up doesn't break any friendship. I think my leader asked something, why you leave? I krijg ook geen Afrikaans praat. Ek is oud en grijs. Ek lief nie vir my kinders. I will never ever lie to them. En as ek kyk na die Sena National was hier verlede jaar terug. Ek dink Honorable Cameron have asked something on that, asked the question to the human settlement MMC. He have asked the question, how long will it be to accommodate the people of Mughairi? He emphasizing, we do have it on record, we do have photos as well, but the question every time, I'm the chairman of that informal settlement, Mr. Lamini, with the council and something there. Then we ask the question, I raise it with emails, then they say, no provincial didn't answer, no national didn't answer, no who's lying for who here? We want an answer because here is Mughairi's people. They said in this High Act, the High Court in Cape Town made a ruling to say that the people of Mughairi, can somebody tell me here?
Yes.
The municipality must accommodate them. We are 7 years. We still in Mughairi. We still at the same place. I'm still writing emails and no one has responded. If I ask the question, no national didn't answer, no provincial didn't answer. From last year, because in July they had a meeting with us there. We do have the black and white. We do have the videos. Then I think in August, Mr. Cyphers ran the mayor read a message to provincial in August because they were supposed to meet between them in 2 weeks' time. The director of human centers or public works, because he was also there. The whole parliament portfolio was there in that informal settlement. Up till now, nothing. We went through wind. It's not me that said so, it's the Pi Act. The first thing I heard this morning. So, who's lying for who here? Parliament is lying to these people that sit here. They're suffering. Or is it a municipality? But somebody doesn't do his work. I did ask even several times. We have this other thing now. They shift from 2005. I've got my license card in 2005. Hulle sê nou vir my hierso, nee, hulle gee my eers van 2006 by agter bewoner.
Ons was nie agterbewoner. Ons was dan agterbewoner.
2005. We are in the process of 2005. But now they say no, we are in the backyard whereas there is 2006. What happened to 2000? Yes, in 2005. I've rendered this photo to the MMC of housing. He didn't answer me. answering till now. No response. There's a problem where we synchronize the leader saying communication is an open tool where people will understand each other. But if you can't communicate, but it doesn't answer us. There is a rallying void. In January, when I ask again, they say provincial did say yes, but it didn't give it on black and white. They say yes, but it didn't give it on black and white. And that's coming from the mayor. I have to ask him directly. I have to inform my people immediately that is out in December. My people can hear me out. They came in there, they say, we got good news for you.
Yes.
Till now, they didn't bring the good news to us. And when the people will stand up, then they are wrong. When they stop the bus is not going to run, they are wrong. But you guys doesn't look at the part where the people that made the promise. I will emphasize it again. Don't let us go against this. I think my colleague has said, who or someone who believes here have said, can be now make criminal charges against the municipality because they didn't follow black and white. They doesn't follow the PI Act. Thank you very much.
Thank you, Program Director, and all that is here. I think we must not cry the wrong funeral sometimes. We must go to the right one. But nevertheless, I've got 6 questions. Are you going to allow me to ask it, Program Director?
Yes.
Okay, thank you. Okay, the first question that I'm asking is, because of the service that the municipality is giving to the people that occupy the land unlawfully, is that why the municipality is the person in charge? Is that why you are giving them that authority to act on behalf of the owner if he's not there? That's the first question. Now, the second one is very simple. How did you get to the calculation of 2 million rand if for a person that is initiating or whatever? The third question will be, why does the bill not mention the national government? They mention the local municipality. As you can hear, most of the people are speaking to the local municipality, the provincial government, but they don't mention the national government that at this point of time is the people that initiating this bill that we are having here. The fourth question is, how will the renovations, I have stated like this, not the way you stated, I have stated as renovations. How will the renovations be calculated and how will people then be compensated according to those calculations that has been made? The first question is, how do we determine the vulnerable community of the vulnerable individuals? How do we determine that? Because as I'm standing here, am I vulnerable? As the people are sitting here, are they vulnerable? So we need to know what rate or what scale is being used to determine a vulnerable person. Then the last question, it's specifically speaking to the farm evictions now. And I'm very clear on farm evictions. And I want us to understand what is it when people are being evicted on the farm. As the bill has just spoken to the 3 people that they are reasoning is the private developers, and then it's the municipality, and then the people that are. Now my problem is that when those people are on the farm and they are being evicted due to they are not working anymore, or X, Y, and Z, whatever it is, but there is a labor issue involved. We need to understand that labor issue is involved. Why is the CCMA or the commissioners of the CCMA not involved or mentioned, I would love them to be mentioned in this bill, because that would give us, as the labor fraternity, more power to assist our vulnerable people. Now they are vulnerable, to assist them on that farms or wherever it is. So I would love that, and I'm going to write to you also, this one that I'm raising. I'm going to write that because we are a group of it. We're going to deal with it, and I would love that to be in the bill, because it's going to be more than fair to include this in the bill at the end of the day, because there's labor involved and there's other people, vulnerable people involved in this. So thank you very much for allowing me this expression.
Good morning, my name is Charlotte Clark and I am a councillor at the George Municipality. Program Director, if you don't mind, I'm going to speak Afrikaans because these people understand Afrikaans. Die eerste ding wat ek wil sê is, wanneer mense net grond kan van besit, dan gaan dit chaos veroorsaak. Wanneer almal nou net 'n stukkie grond, ja, ons verstaan die land behoort aan almal, maar as mense nou net gaan sit en 'n stukkie grond beset, en soos die meneer gesê het, wat gaan word van die dienste, wie gaan betaal vir daai dienste, en mense, ek sê nie, dan moet nie dienste wees nie. Dit gaan chaos veroorsaak, want elke jaar rap en sy maand gaan dan nou net 'n stuk grond opvat, en hier is ek en ander wat sukkel, ons mag goed lyk, maar ons sukkel om te betaal vir 'n stukkie grond. And I'm not saying these people mustn't be accommodated, that's not the point. Ek voel net daai gedeelte moet goed deurdink word. En dan, Mr. weet jy, ek is nou al op 70 en ek het vlaggenskappe gesien. En ek wil so graag hê, ons moet op die rassekaart gooi mense. I walked amongst poor whites, I walked amongst poor colors, I walked amongst poor blacks. We're all experiencing the same thing. And I'm not trying to be nasty or funny, but I have seen poor white people who do not have a job, who do not have food. And it's not, at the end of the day, it's not about race. Al wat ek sê is, Mr. Amini, ek voel vir julle, I do. And I'm not saying that we cannot try to accommodate people, but let's keep the color out of this. Yes, we are talking about Pacaltsdorp, about George, and I know people don't like me for the things I'm saying, but why must we be scared to highlight the things that is the core issue that is dividing us?
Yes.
Why are we doing that? I also struggle, even though I live in a house. There's many other people. And you know, and he asked the relevant question, we all blame George Council, even though they're working their asses off to accommodate people. If you go in there and you see what we are sitting with, then you will have a different story to sing, or a different song to sing. Councillor Cyprus is working so hard because there's the black people that is coming to you and saying we don't get this, us that's not coming.
Sorry, ma'am.
I'm not saying we must.
Can you please give her a chance? Nobody interrupted when all of
It is
you
really not as
This
easy
is allowed, whether you
as...
agree or you don't agree.
I'm just trying to say it's not as easy as it looks, Mr. Lavini. I know people, I mean, family members who come up from squatter camps, but you know, they saved, they struggled in order to get something in their lives. And Councillor Cyprus is struggling. I see it, and he's doing a good job with what he's doing currently. But you know, it's not just the George Municipality. What about the government? We all blame local government, provincial government, and as he said, this is about the PIE Act. It's not about human settlements as such. That must be discussed on a different platform. It's land grabs that we're talking about today. That is the core issue here. And it is so when we grab Program Director, it is a fact when we go and grab around and it's an issue, but when others do, then it's not such a big issue. We must highlight that also. And the other thing is, I know people who come from other provinces, who come and grab land here, but they have houses that size, whereas the people in George cannot get houses. Mr. Lamini, I know of people who have properties that size. They get free houses here, and that is what troubles many of these people. What does the government do to curtail that or decide? Is there a system where the government or provincial can find out who owns more than one property and who comes here and get another property for free? That is the biggest issue, I think, and that is why we cannot get proper houses here. And the other thing, and maybe this is just a human settlements thing, Councillor Savers, but you know, when you give somebody a house, please make sure that it's a decent house, that it's built properly. Because I've seen the destruction in Roseville, I've seen it in Roseville Park, we see it in Newdon Farm. Somebody has to keep the builders, somebody has to keep them accountable for the mess that is created when people are living in. Thank you.
Thank you. Please work with me. Let's ask questions and hands, but let's not make a speech because then it's going to take a lot of time. We're going to lose the essence of our presentation process. There were two hands that were here. Yeah, you can take it. There were two hands here. And then you can finish that.
Goedemiddag, baie dankie. In George. Afsprake word gemaak, dit word nie nagekom nie. As jy daar navraag gaan doen, dan sê dat daar dokumentasie wat daar nie hoort nie. Die dokumentasie is ingevul. Vir 3 jaar werk hulle aan die lys al voor 2005. Impossible. Ek is baie jammer om dit te sê vandag. Ek het weer maar terug en ek 'n e-mail gestuur van Nationals regarding behuising. Antwoord gekry, dit is George Municipality. So George Municipality moet vir my sê, wat is die prosedure om 'n huis te bekom en hoe allokeer hulle die huise? Die ander ding is geen kommunikasie word met ons as gemeenskap gedoen nie regarding die nuwe wette. Ek hoor nou die meneer praat van rentelhuise. Waar is dit in George? As ek mag vra, baie dankie.
Goeiemorgen. Ik heb toen dat ik aanspreek voor een wonen. Toen dat 14 keer in 2000 apply. Misschien als we 2 keer maar terug. Er waren 2 dames en die piekje waar bij hem gereden. Alles met dat brief in de hand gaat voor mij. Maar ik wil niet meer spelen en weet. Wat was de reden dat bij mij niet weggereden met die brief en dan gaan we weer terug naar mij toe. En dan komt nou nog terug naar mij toe. Maar ik kreeg plakjes aan mij. Maar ik anders niet meer nooit bij je. Als ik plakjes kan bouwen, ik nooit bij je. Daarom niet.
Baie dankie, die voorzitter. Baie dankie George vir die geleentheid. My naam is Tersis Jones. Ek is van wijk 1 in die meeste municipaliteit. So ek het 'n bietjie ver getrek om hier ons punte te behandel. Meneer Speaker, moet jy nog geluister na die hele opsomming met alles. Die bil en om te begin, moet ek nogal sê, ek is baie teleurgesteld aan die vorige spreker wat gepraat het. Ek dink sy het voorgestel as 'n raadslid. Ek dink dit is die tyd om politiek te speel. Sy het mooi dit genoem en gesê, sy bly in 'n huis en die mense moet dit gaan plak. Weet sy hoe voel het om in 'n plakkerskap te bly waar ons nou hier 'n storm gegaan het en sê na huis gesit het. So die politicians moet ophou met ons lewens, politiek speel en hulle moet ophou sê hulle weet hoe hulle voel en hoe ons voel, maar hulle bly nie saam met ons in die plakkerskap nie. Meneer die voorzitter, ek sien as 'n bil wat maak nie saak wat ek input ons nog gaan gee nie. Die goewerment gaan maar die bil in werking sit. Kom ek sê gee enig of so 'n klein bietjie geskiedenis. Hoekom ek vandag eintlik hier is? Die 17de Oktober 2025, wat laas jaar is, toe gaan vat ek saam met die mense wat hier sit en nog 100 ander mense. Toe gaan vat ons munisipale grond. Die rede hoekom ons munisipale grond gevat het, die afgelope 20 jaar as ons mense aan die wag is. Die oudste persoon wat in die informal settlement bly, is 70 jaar oud. Nou kyk hoe lang dat sy is. 70 jaar as sy op 'n waglys. Die rede hoekom ons gaan vat het, is omdat die munisipaliteit hulle gatte in ons aflê. My vraag is, hoe jaag die nasionale regering en die provinsiale regering ons munisipaliteite? Nou praat ek in terme van Nyasa munisipaliteit. Nyasa munisipaliteit kry elke jaar bedrag geld van die provinsie en van nasionale regering af. Laas jaar, by die vorige finansiële jaar, was daar 32 miljoen rand uitgesit vir behuising. Ons kan nie bou met daai geld nie, nie huis net vir implementasies. En die 32 miljoen rand was weer teruggeneem, waarby daar 8 miljoen rand oorgebly het. September verlede jaar, toe van provinsie weer die 8 miljoen rand terug, want Nyasa munisipaliteit werk vir die geld. Ons kom nou van 'n hofsaak af. Die saak het daar gemaak die 28 April by die High Court in Maneto. En ongelukkig het die judge gerule in favor of the community van Maneto gaan ons so wees. Nou kom ek terug na weer na die mense met die tafel. Hoe jaag julle munisipaliteite? Onze volgende beklei wat ek nou beklei is, ek is bly is delegasie van die Nyasa munisipaliteit van behuising. Onze mense sit vanaf 17 Oktober tot en met vandag toe sonder basiese dienste. Section 27 of the Constitution of South Africa sê dat as die ons wille lewe, as die moed wat ons basiese dienste het. Dan kom my vraag weer, ons wil nie in informal settlements bly nie. Ons wil nie in informal settlements bly nie, maar ons bly daar, omdat daar nie ander keuse is. So, my vraag aan die munisipaliteit is, aan die munisipaliteite en aan provinsie. Provinsie, kan julle nie saam met munisipaliteite gaan gesels, human settlement gaan gesels en gaan implementeer reblocking. UISP Space 3 praat van reblocking, dan praat ons van categories. Dat is category A en category B. Reblock onze informal settlements, geef onze mense services. Dis nie dat ons dit wil nie. Ons kan ons eie huise bou. Reblock vir ons, sê hier is jou voordeel, geef ons die boundaries, dan sal ek vir julle wys, ons kan ons eie huise bou. Baie dankie.
I've already introduced myself earlier. I think the House knows who I am. My name is Vayeso Manaka. I'm from the Provincial Department of Local Government. But I think it is important that I gave my input as a attendee, as a stakeholder. But I just want to highlight the fact that I think the House is now deviating from the core agenda, which is the bill. And now many times, when Parliament reaches out, either the national departments, be it provincial departments, are reaching out, we don't stick to the agenda of that particular day. We rather deviate to raise some other issues that are affecting us that needed to be undertaken, or attended by the municipality, so that we don't do. At the end of the day, this exercise becomes a fruitless exercise because we really don't speak to the content. But I want to be very positive, in just giving 2 or 3 points to the bill. I just need to check what is it that can be done for the interests of national, provincial, and local when such bills are presented to the communities. Can't we have a link of such a bill to influence the municipal policy? So that when this bill is finalized, at the end of the day, there's no going back, but there's a clear or critical understanding from the municipality side in terms of the policy position the municipality will take in line with what the bill is seeking. The other one is in terms of land availability. I think the bill also needs to indicate to any level, at a local level, so that we understand which land belongs to whom. So that when municipalities are developing their communities, they exactly know that this piece of land belongs to Jan, or this piece of land belongs to Kibere. So that the process of eviction, if it happens, it doesn't delay. It is addressed with immediate effect. So that they don't take years to let people to stay in a land which they don't know who's the owner of the land. I think we need to look into that as well. But also, finally, when this bill is finalized after consultations, what is it that the department can do in terms of giving feedback? Sometimes we consult, but when the final product is concluded, we don't come back and give back. Lastly, I would also suggest that, consultation, when we have such consultation, we identify the relevant people. One example I can give you, where evictions are happening in George, I can speak of Union Gate area. There's many people that have been evicted in that area every day. So, when this bill need to inform us, that the most vulnerable people is the people that we need to reach out to. I'm not saying Pacaltsdorp was not the right venue, but in terms of relevance, you understand? Because people of Pacaltsdorp are more having issues about the municipality more than the issues about what the bill is seeking. You understand? So next time I think we need to consider that where is this thing happening that the bill is seeking? I thank you.
Thank you. Can I recognize the last stand? The last stand. You see the only one?
Okay, that's up.
Then you are the last one. Then we'll take the responsibility.
Okay, ek gaan sommer praat so ek's fyn. That's fine, ek gaan sommer net so praat. That's fine, maar ek sal is okay. So die stem is daar toe. Yes, as jy sê the best for last, né? Ek wil net aansluit by die manier wat nou gepraat het van die expropriation van land. Nee, ons is op 'n tydbom op die oomblik, en soos ons op die leasing, die maars voor maars, nee, rondom die unlawful illegal foreigners. Nee, wat ook nou kom in ons land onbeset, wat het swaar maak op die oomblik, en wat in ons streng sit op die behuisingskwessie van onsself. Ons gaan sien op die oomblik, wat gaan in ons lokasies aan en hoeveel taxshops is daar op die oomblik. Ander is wat ek van oorlog praat, jy het gepraat van die rental, die munisipaliteit stel rental huiselik beskikbaar vir ons mense. Hoekom die rental omskep aan rent to own? En dan kan ons mense sê, luister, jy het geen waardigheid, ons kan al eienaarskap van die huise vat. Ander ding is, ander punt wat ek net wil raak is, julle sê ons mense gaan beset op illegal grond. Nou as jy van George, even Pacaltsdorp, soos wat op die oomblik gebeur hier in Pacaltsdorp, hoeveel van ons gronde word benut deur developers. Ons het seker in Pacaltsdorp en die hele George die grootste vacant grond vir alternatiewe behuising vir ons mense. Maar elke keer word daar beloftes gemaak, het word geprioritiseer en ons het omtrent iets soos 5 informele, 5 of 6, as dit nie meer as informele nedersettings in Pacaltsdorp. Hoe lang moet Boegeheer Boegeheer is dink die tweede of derde informele nedersettings. Dis illegal grond wat nog is van provinsiaal. As hulle die eerste is die dames sê daar. Maar wanneer word daar ordentlike behuising vir hulle beskikbaar gestel of alternatiewe grond soos die aktivis gesê het daar so selfgrond vir ons mense beskikbaar. Ons mense het die vaardighede om te bou, maar die ons het op 'n tydbom op die oomblik. Dan kom ons met bills wat moet gepas word vir illegal eviction. En julle kom hier so om die bill, om net public participation te kry, maar ons weet, dis maar net 'n formality wat julle hier is, die formaliteit is dat die bill gaan in elk geval, wat ons sê, so gaan in elk geval gepas word. So laat ons kyk op die goede, dankie.
Good morning, everyone. I have 2 questions. How does this bill affect disaster victims? Ons het sopas ons nou 'n storm gehad en daar's mense wat ons nou huisloos gelaat is. So ek wil graag weet, hulle gaan ons nou daar bly, hoe dit hulle gaan affekteer. Dan my ander vraag is, hoe hierdie bill die mense in informele nedersettings gaan help. Soos meneer Lamini genoem het, National het gekom, hulle het gesê munisipaliteit moet kyk dat die mense daar geholpen word, tot nou toe is daar nie geholpen. Hoe kyk ons dat hierdie dinge wel gebeur vir hierdie mense in die informele nedersetting? Want as ek so kyk, staan die klomp leerhuise, woningkies, as geld beskikbaar gestel, die huise is gebou, maar die huise word nou geplunder. En hier sit onze gemeenskap, soek behuising, hulle het die wonings sien, maar ons huise word geplunder. En dan 'n ander teelpuntjie waarmee ek sit, as jy nou gaan kyk daar, die illegal foreigners, hulle bly dan in die huise, en hier sit ons, hoe bly die illegal foreigners of hulle maak winkels in die huise, en dan sit ons mense, waarom die ek dan in die baie ek ook nie weet, die Eviction ek vir hulle, want hulle bly dan in die huise, en hulle word hulle nou iets doen, hoe word die mense dan so beskerm, en hier sit die mense, in informele nedersettings, en regtig waar ek weet, soos, mede collega nou gesê dat, die mense bly daar, die mense het nie geld vir behuising, they don't have money, that's why they staying there, as hulle geld gehad, denk ek, so hulle vir hulle huise gekoop het, hulle bly in die plakkerskampe, omdat hulle nie die geld het vir behuising. En dan het 'n ander vraag wat ek het is, daar's mense in hierdie informele nedersettings, wat op die behuisingswaglys is, maar hulle kan nie, hulle huise kry nie, want dit word vir hulle gesê, hulle is nie backyard dwellers nie. Maar ek vat dit so, hulle staan eerder af as 'n backyard dweller. Hierdie mense bly sonder water, sonder krag, baie van hulle in moeilike omstandighede, hulle is eerder af. So, hoekom word hierdie huise van hierdie mense afgehou? So dit is hierdie dinge wat ek wil hê, die departement net inkyk vir ons, baie dankie.
Thank you very much. With the last person.
Goeiemorgen allemaal. My vraag gaan eindelijk spesiaal as die kansels hulle. Heiliglik sit ons met huise wat geplunder word. Dit was al hoeveel keer geplunder. En die bil wat julle nou hier ons nog voorlê, hy soos my collega ook sê, dit is 'n bil wat deurgaan. En ons mense wat in plakkers, ek bly self in 'n plakkerskamp. Ons wat nie net grond omdat ons wil nie. Ons grond word aangekoop aan ryk investors. En dan sê ons eers voor keer op hy grond nie. Lekker gaan op. Dis nie vir ons mense nie. Ons mense kry nie grond nie. Ons moet vat. We have to take by force. And then you have the bill, the new bill that is coming in. That wants to evict us or give us a 2 million rand fine. I don't think that's right. And in George municipality, especially in George, as I have been living here for 47 years now, the only time there is been speaking or housing is mentioned is when there is elections. That's the only time.
Okay, thank you very much. That takes us now to the end of our inputs. Now I will ask Mr. Massimula to respond to the inputs. Please bear in mind that some of them might be detailed, some of them might not. But what also matters the most is that you have made the input and also we will share the responses now with you. Thank you. You can clap hands for yourselves.
Thank you very much for the question. The question of the 2 million I'm going to try to do what the gentleman spoke about as to how we end up with 2 million. I think we must understand that we are trying to balance different interests and rights of various it's you have the section 25 of the Constitution that guarantees the right to ownership of property and so on. And in doing that, you don't want a law that will be seen to be protecting only one section. But in this bill, if you will notice, we are not necessarily punishing the people who are occupying land without authorization. But we are punishing those who run business of inciting people to occupy land. So that is where we are. And we think we must have a deterrent to those people. So that we continue to have an orderly way of providing allowing the municipalities and government in general to be able to give our people services as expected. Otherwise, if we will not do that, it might mean this government will be the second name today, tomorrow is another one. It will just find the government in a mess, or rather the country in a mess, if we do not contain that by at least bringing deterrent, but also making sure that we continue to do services as expected. He had asked also, why is it the municipality that should provide the services? I think the reason is that irrespective of the constitutional court in pronounced in several cases, is that the municipality is the one that is closer to people. That's why we have IPPs where closely communicate with your municipality and say, in this piece of land, you want a clinic. And you're expecting that the officials, including the politicians in the municipality, must respond and account by what happened to that clinic. And if some people then occupy that piece of land for other reasons, then it becomes a problem. Because not every piece of land is meant for human settlement, for people to stay. But you can have various reasons. Remember, clinics is a human settlement issue in any event. Because the department is no longer providing, it's not the department of housing, it's now human settlement. So if we give people a piece where they can stay, we want to make sure that there's a clinic, there's a school, all those kind of things, there's roads and all those things. But what we're trying to say is that the municipality is the one that is closer to the people and must be the one that takes the responsibility of ensuring that these things are well controlled. And the province is included in the whole papers and not the national. Because the national department is not implementing any programs of housing. So they will start from the province, and we thought that if the province is also allocating money, national is province, and to a certain extent other municipalities, but I don't think this one George does get money directly, but the metros do. So what then it means is that when there's a need of alternative accommodation, it will not be in a situation where the municipality will then say, after the case has been finalized, and say, in fact, we do not have money. And when that happens, it means you must still go back to court and ask court to say, the municipality does not have money. And the municipality then says, let's join the province. And that takes time for resolving these issues. So we thought that the province should be closer and not only the province, by the way. If you feel that you want to do the national, that's why we're saying any other interested man, you are free to do that, but we are trying to limit it in such a way that if you have many parties to serve notices, it might be also costly on sheriff's fees. So we try to minimize that and say who is actually relevant as an entry point, and we said the province can indeed help us to address those things. And it was asked why the regulations, how are they going to be calculated when regularly removed or evicted, and they have made some improvements. So how is it going to be done? There's no, we can't say 1 plus 1, because it depends on what you present to court. You say, I've agreed to this landlord to build this room, and when I build this room, this is the amount I've spent. And you are able to show the proof of that. And that's when, or if you have written it down in the form of an agreement with the land owner that I will build extra room because I need extra room here. The one that you are providing is small, I must extend it. And this is the amount that I have spent towards this. And you know, if at any time when you leave, that money must then come back to you. It's not your property. You will just make it comfortable for you at that time. Because otherwise, unless it's the arrangement you extend this room, you will stay for the next year without paying a rent. It would have been written. So I think it's encouraged that when you engage in this kind of building or renovating a place that is not your own, you are renting it, and so on. You must just make sure that there is clarity of how much you spend, so that you do not lose your money at the time that you must leave the place. They asked about the vulnerable groups, and they have indicated that the vulnerable groups are, remember the PI Act did not want to say that everyone qualifies for alternative accommodation. There should be a way of determining who qualifies for it. And we are saying children, elderly people, women headed households, and persons with disabilities, but also taking into account that they are indigenous people that when you provide those people, because you have to provide them and see who is in unlawful occupation here. And then you are then able to find out whether these people are working or not, whether they are not working but they are selling some goods and they are able to have some form of income. So, because sometimes people think that when you are not in a formal employment, you are not having an income. But the profiling will then guide saying this one will not necessarily have any form of an income, and therefore they will then qualify for other programs that do not need someone to have money, such as the ones of IDPs, because you will not be having access. But if you earn a certain amount of money over, I think it's 3,500, you will then qualify for other programs, as I've indicated, the one that in the past they used to call it the fees. That is the first one you finance. You will find that you qualify for the house that, or rather you want a house that you've identified. It's a house that it's better amount of, say, 300,000, I'm just giving it as an example, and you realize that you do not qualify. When you go to the bank says you do not qualify to have an account for that house. You then go to NHFC and the bank and tell them that you want what is called fees, and the fees includes what you do now called first of finance. It will pay a certain portion, saying that the bank says we can only do 200,000, not 300,000. And then the other portion is then paid by the department, so that it will maybe be the one of the two, 200,000. 200,000. So you are able to meet you halfway, so that you will proceed with the other portion. So I'm just saying we have those kind of situations. We have situations of rentals, as I've indicated earlier, and we find that we actually qualify for rentals. We have heard that there are people who stay in these houses for a few months and they leave them because they do not live with the actual house. but they need it for other reasons. They just want to sleep there and during the weekend they go back to their home somewhere else far from the area. But they do not want to travel on a daily basis. They want a local place. On the farm eviction side, there is most of the farm evictions from where they are. The farms and the people who are there are the former employees of that farm. There is a law called in short we call it as the extension of security of tenant act. It was promulgated in 1997. It operates almost similar way with the pie. It protects those people who are in the farms against unlawful eviction. And as I'm saying, I'm repeating that unlawful eviction largely is when someone just decides to take you out of his or her place without getting what to do. Just realize that you no longer want to hear, you must leave. And with this bill, we are trying to avoid those kind of situations. Because if we are not intervening, you will have a situation where a certain section of our people, either the landowners believe that the unlawful occupiers are more protected than them, and they just wake up and come to you and say you must leave. You say, when is it now? And by the time you are in court already your own estate, and finding more joy after that time. So it's important that we continue to try to balance this interest and rights with the mom here asked about if we can or are they giving 90 days and there is no alternative accommodation that has been given to her. And you see, one of the mistakes that people do, when we are sitting with the court documents of eviction, we just sit there. We do not even go to court. And the court will not have an opportunity of knowing. And knowing you, I mean that they do not, because if you don't present the side of this world, they do not know whether it's a child-headed family, whether it's a woman-headed family, whether you are a person with disability. So they will issue eviction order and just say, you must just go and not know your situation. But if you go and present your case and say, I no longer have money, I'm here and I want alternative accommodation for example, then the court will entertain that part of, if you are taken out, where will you, who must help you? And the owner perhaps will say, I do not have money to help you. And time again, you know that the owner would have invested his asset towards that building and it does not have extra money. So they will spend it because it's cited with them and say, okay, we will find a place where we can put in the meantime we are processing other things. This person has been registered on housing needs register, and then we try and follow it up if you then qualify for which program. But I would then, because it might be that it has happened after. She may not have got there, but I will encourage her to go to legal aid. They should be legally involved in their mind. It's legal aid South Africa. It's now called legal aid South Africa. You go there and brief them the situation. And don't wait for that 90 days to come. Because the 90 days, it means people who will come to you are the sheriffs. And they will wait. So I will urge them to go to legal aid South Africa and tell them their situation. those are lawyers. And they will assist their fellow charge. And I would suspect that they will have to take a letter to court and say, this is what happened and I do not have a place to stay. Even within the 90 days, I do not have a place to stay. But if you have another alternative indicator, I just need extra money to allow me so that I can be able to move to another place. So I will encourage you to do that. Well, I think these are the questions that we really directed us already. But I just want to indicate that on the issues of the housing allocation and the challenges there, the National Department is in the process of developing an app that will allow you, wherever you are, sitting in the comfort of your home or wherever you are, to can check on the phone whether how far are you with the application that you have made. If there's a delay, you can get clarity for the app, why is there a delay. If there's something that you must prevent, it will indicate to you so that we do not rely on people who can change these allocations depending on how you are looking at. If you are happy, Sundowns has won, or Pirates is taken, we get a good service, and if Chief was getting, you are not going to get the service. So I think it's the system will help us to be able to smoothly deal with our challenges that sometimes are human problems that are created by our people when we allocate these things. The bill is not going to operate retrospectively, meaning that it's not going to affect situations that have already happened. So it will move forward. So those who are lawfully occupied land and all that, it will not really be affecting them, the amendment, in a different way from the ones that we are now using. So that's what I just wanted to indicate that it will not say in 2025 you have committed an offense because you have incited people. It will not happen that way. It will happen once it's now has been signed by the president. And that's when it will then be operational moving forward. So this amendment will then be included into the act that we currently have. Thank you.
As we are aware, the Councillor Cephas is among us. He has been waiting patiently and listening to all your inputs. Now he's listening to make his inputs. Thank you.
Thank you very much for allowing me this opportunity. But I would like to speak in Afrikaans because that's my mother tongue and I think the people will understand me if I can speak, if you don't mind. Ik dink ek moet met u saamstem. You have raised so many things which is relevant to me as a Ministry of Housing. Last week, I went to, kom ek sê, verlede week was ek so 30 kilometer buiten dat Lion.
En as ons dan ons en behoeftes, kom ek sê, dit was vir my die seerste prentjie om te sien hoe is mense gedestrooi. Geen inkomen, geen ander alternatief. Nou kom ek sê, het is baie lekker om hier te kom, om pak te gee, op pak uit te deel, maar kom ek gee vir jou die realiteit en die bestaan nie. Ek gaan vir jou vandag alweer 16 doen. Grond, alle grond en grond, wat sy hier maak is, bewijzen, ons moet eers impakstudies maak, om te sien of het werkelijk leefbaar is, om so, dis hoe die proces is. Ons kan allemaal hier kom in een talkshow, en wat om die so teleurstellend is we talk about the amendment bill, en ons kom vandag hier so, en allemaal kom sing oor en sing. Ek wil het ook gee my kans hier te kans aan. Geef my een kans hier te kans aan. Kom ek sê, en ek wil het om onderstel. As mense dink, hulle gaan die system in kry, ons gee nie vir kinders huise. Ek gee nie vir kinders huise. I will give houses for those who make the criteria. Kom ek gaan terug na die I want to give you to the amendment bill. I think we should go, as mentioned by my colleague on the left-hand side, that we need to go and sit down as a different species. Because I think there is a ripple effect when it comes to, that will have a message, that will be the starting point of I remember your proclamation was done as the national government in 2007 when it comes to low cost housing. Now, if you see what the municipality, and we've been mentioned here the whole day, and I want to also emphasize this to my little friends, that we are the implementing agent. The municipality are not there to decide. We the implementation agent for national and provincial. But let me continue by saying this. The reason why I'm saying this is because your threshold is promulgated in 2007 and we actually in 2026. You are 90, we are 19 years that we should go to the drawing board. Because if we can start on that platform, engaging on that, then we can actually reduce the pressure of land inflation. That's the first thing I want to raise to you. We need to sit and discuss this. Because let me tell you something. Prior to 1994, we had 500,000 backlogs in this province. And we are 2026. So we're 31 years down the line. And that's why I'm saying we need to seriously engage with one another, local, provincial, and national, and discuss the way forward. We can never just come, and I want to say to you, I'm not here, I want to see that the people sitting here, it's for me actually painful. That is vir my seer, om vandag hier te kom sit, te kom staan, en ons discuss die amendment bill, waar inputs moet gegee word, soos hier gesê het, met die brein sê ek, dis maar net 'n formaliteit. Ek wil meer gesien met ons praat oor die amendment bill, en ons kom praat vandag oor behuising. Dit is 'n issue vir 'n later stadium. Kom ons praat daaroor, kom ek sê, wanneer jy 'n counselor is, dan is jy veronderstel om hierdie goed met jou gemeenskap te deel. Of nooit, dan kom praat ek met hulle. Hierdie is so kardinale belangrijk om te weten waar ons besluit oor die amendment bill, en ons het die hele dag as ons gekom maak met behuising,
informal settlements en hy tipe van. Dit is nie waaroor die session gaan dit is. Dit is kom ek sê, ek dink jy sien jy hier gepraat dat ek die kans gegee. Ek dink ons moet 'n bietjie respek hê vir mekaar. Hier die geleentheid gehad, maar kom ek wil nie langer. I don't want to delay. You see that's what happens. It's when people and I'm going to say this, when people coming with their own agendas, it's agendas that try to be driven. But I'm telling you now, I will never be shaken by these people. I'm going to give the face. Mense ons moet opkom, dat mense ons gebruik om hulle agendas te probeer bereik. Kom ons sê, ek dink dat die province, and I must say this also to you, this province, last year in June, we has given 2,312 houses with libraries. And we're still working on providing housing. But anyhow, I'm not going to be like busy. I'm going to thank you and your team for coming to make this possible, to have a big engagement with the community. Also, province, I want to thank you for coming and the rest of the team, the NHPRC councillors, and especially the community. Thank you.
Thank you very much. I just want to elevate a few areas that were cited. Let me leave it to the experts. Thank you. Let me just appreciate your time. That you came to make your inputs. And I'm aware that most of the points that were raised, then they were around informal settlements, BMG houses, and so on. But that is understandable because shelter is a priority for all of us. If you don't have room for your head, you are a very one person. It happens to all of us. But also we must start to begin to understand shelter. There is no longer shelter. The house is an investment that also we must be able to leave it for our generations. I do take a point that there is a need for improvement in terms of communication and engagement amongst all spheres of government, that is national, provincial and local, and also among the communities. Their communication and engagement should start now to extend to local leadership involving the local councillors so that information will flow and continuously members of the community will be able to know various issues. I fully understand why the issue of farm workers and evictions thereof is a priority because this is George. This is a matter that hits home. I'm happy that you did also find a space to elevate it because it is a reality for you. The matter of renting of informal settlements is no longer informal settlement, it's now business. We are aware that there are people who erect shacks and they rent them out. So it's now business. It's no longer the perception that says people that are in informal settlements are the poor ones and so on. It's now being diluted. But also there is also a sad part of it that some of the beneficiaries that have received BMG houses, they rent them out and they go back to the shacks. Or they sell them. And then they go back to the shacks and then they pretend as if they never benefited. we also have to take the responsibility and do the right thing. The issue of language, thank you for raising that. The gentleman has just left. We will be cautious of that next time. We know that George is mostly African speaking, so that we will be able to package ourselves when we come to the areas where certain languages they are prominent. Just for last thing, are there any announcements around lunch?
Okay, thanks, DCG. Good afternoon to everyone. We have enough text for everyone, so we request that you remain seated and then